Imagine this. A director has been sitting on the board of a listed company for 12 years. Highly experienced, well respected, attends every board meeting. Management trusts him completely. Investors know him well. Everything seems fine. But suddenly, the company becomes non-compliant under SEBI regulations. Why? Because shareholders were never asked whether they wanted him to continue. Now imagine another situation. An independent director resigns. Management decides to fill the vacancy later. After all, what difference can one vacant seat make? 3 months later, the company faces a governance compliance issue. What went wrong? Today, we will decode two of the most important governance provisions under Regulation 17, the 5-year shareholder approval rule and the 3-month vacancy rule. Stay till the end because I will show you a simple compliance formula used during secretarial audits and IPO due diligence reviews. Welcome to Corporate and Securities Law Compass, the channel where corporate laws, SEBI regulations, FEMA, corporate governance, and secretarial practice are explained through practical examples and real-world compliance situations. If you're a company secretary, compliance officer, director, CA, CMA, lawyer, investor, or law student, subscribe now. Let's begin. Quick question. Who decides whether a director should continue indefinitely on the board? Management, the chairman, the nomination committee, or shareholders? Keep your answer in mind because Regulation 17(1)(d) is based on this principle. Regulation 17(1)(d), the 5-year rule. SEBI introduced a powerful governance concept from the 1st of April 2024. The concept is simple. No director should continue indefinitely without periodic shareholder approval. Therefore, every director covered by this provision must obtain shareholder approval at least once every 5 years. Think about what SEBI is saying. Even if the director is experienced, even if management likes the director, even if there are no complaints, shareholders must periodically decide whether the director should continue. Why did SEBI introduce this rule? Because board accountability should not be permanent, it should be renewed. SEBI wants greater accountability, better governance, enhanced shareholder oversight. Periodic performance review. In simple words, no unlimited board tenure without shareholder involvement. Practical example. Mr. A was appointed as non-executive director on the 1st of July 2024. 5 years expire on the 30th of June 2029. Before completion of 5 years, shareholders must approve his continuation. Simple. Secretarial audit trap. Now comes the important transition provision. Suppose a director was already serving on the 31st of March 2024 and shareholders had not approved his continuation for 5 years or more. What happens? SEBI says approval must be obtained in the first general meeting held after the 31st of March 2024. This is a favorite audit checkpoint. But here's the interesting part. Does this rule apply to every director? The answer is no. And this is where students often lose marks in examinations. Exemptions you must remember. The 5-year rule does not separately apply where approvals are already governed under managing director provisions, whole-time director provisions, independent director provisions, manager provisions, directors retiring by rotation where shareholder approval already exists. Why? Because shareholder approval is already built into those frameworks. SEBI does not want duplication. Court and regulator appointed directors. Suppose a director is appointed by NCLT, court, tribunal, government, Financial Sector Regulator. Will Regulation 17(1)(d) apply? No. These appointments are specifically exempted. RBI nominee directors. Another favorite examination question. Suppose a bank nominates a director under a lending arrangement. Does the 5-year rule apply? No. Such nominee directors are also exempt. Golden memory formula. Remember this. every 5 years, ask shareholders again. That's Regulation 17(1)(d). Regulation 17(1)(e), the 3-month vacancy rule. Now let's discuss a provision that every company secretary must monitor continuously. Board vacancies. SEBI does not want board positions to remain vacant indefinitely. Therefore, any vacancy in the office of a director must be filled at the earliest and not later than 3 months. Practical example. Independent director resigns. The 1st of June 2026. Latest date for filling vacancy, the 31st of August 2026. Beyond that, the company becomes non-compliant. Why does SEBI care? Because a vacant board seat affects governance, board effectiveness, committee functioning, decision-making. Regulatory compliance. SEBI expects proactive succession planning, not reactive management. Suppose the resignation creates a compliance problem. For example, audit committee composition becomes deficient, NRC composition becomes deficient, risk management committee becomes deficient, stakeholders relationship committee becomes deficient. Can the company wait? Absolutely not. SEBI expects compliance to be restored at the earliest possible opportunity. Real-life case study. Board strength equals 6. Independent directors equals 3. One independent director resigns. Now only 2 remain. The company may immediately face governance compliance concerns. Therefore, replacement must be identified and appointed quickly. This is why succession planning is critical. Secretarial audit checklist. Whenever you review a listed company. Question 1. Has any director completed 5 years without shareholder approval? Question 2. Was transitional approval obtained after the 31st of March 2024? Question 3. Does any exemption apply? Question 4. Has any director resigned recently? Question 5. Was the vacancy filled within 3 months? Question 6. Did the vacancy create committee non-compliance? These 6 questions identify most Regulation 17(1)(d) and 17(1)(e) issues. The 30-second compliance formula. Remember only 2 rules. Rule 1. Every 5 years, review director continuation. Rule 2. Every vacancy, fill within 3 months. If you remember these 2 rules, you can solve most practical questions instantly. Today we learned 5-year shareholder approval rule, transitional provision exemptions, court and tribunal appointed directors, RBI nominee directors, director vacancy requirement, 3-month timeline, committee compliance impact, secretarial audit checkpoints. Before you leave, answer this question in the comments. What is the bigger governance risk? A. A director serving too long without shareholder approval? Or B. A board vacancy remaining unfilled for months? Comment A or B below. In the next episode of the Regulation 17 Masterclass series, we will discuss Regulation 17 Subclause 3, Compliance Reports before the Board, Succession Planning, Code of Conduct, Directors' Remuneration, Secretarial Audit Red Flags. Subscribe now and continue your journey with Corporate and Securities Law Compass. Thank you for watching. See you in the next episode. Disclaimer. Viewing this video or accessing the content on this channel are free and does not create any professional, advisory or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The Speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the Speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The Speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.